9 months after he was, out of that position, the president of the Court of Appeal, remember headlines almost all through last week, says, he's been asked, or the president has been asked to reinstate him. So that's where we start off this morning here on Sunrise Daily. And Mr. Olasupo Shasore joins us now, Senior Advocate of Nigeria and former Commissioner for Justice in Lagos. Thank you for coming on this morning.
Thanks, sir.
Well, looking at that alone, I mean, it raises a lot of questions for laymen, as it were, because they wonder, what is going on in the judiciary? Because they thought that at the time, this was a man who, from their perspective, concealed, in their own words also, you could correct that if it's wrong, how that he was asked to do something which was unbecoming of a judge in his position. He didn't say anything about it until he was asked to post that somewhere else. And people thought something was wrong. They presumed that if that has been happening in the judiciary, something was also wrong. And now, he's asked to go back to the office. And is that a punitive measure, or how does it work?
Well, the National Judicial Council is a constitutional body, and how they work through an investigative inquiry panel, commission sitting type arrangement. And you can only assume, and I'm not a member, you can only assume that the present recommendation to the president is a result of those inquiries. They've had people testify before them. They probably had a better opportunity to look at the facts. So the punitive part of it could only be in the term of an interdiction. The suspension was for pragmatic purposes. You couldn't conduct that kind of inquiry with the subject of the inquiry, if you like, still in office. So I think it's the proper step to take.
But would people be wrong to say that there seems to be some political twists to all of this? Because politicians, remember, they also need to think of this thing, and they react and say, wait a minute, they don't see this as just being straight or clear as lawyers may see it.
Well, I'm biased. Let me just declare my interest. I'm biased because I'm a lawyer, and the National Judicial Council is made up of lawyers, and very eminent lawyers for that matter. And my bias is to assume that the decision that comes out of the National Judicial Council is not political. It's legal, it's cold, calculated, factual analysis of the law with the best interest of the judicial community, the rule of law and order in mind. And I think it's useful for Nigerians to make that assumption. Institutions are built and institutions are revered based on the benefit of those assumptions that the public gives them. When we begin to, first of all, second-guess our haloed institutions, it reduces, it demeans their quality. And these are structures that hold the society together, however invisibly. So I'd like to say that I think it's safe for the public to assume that the National Judicial Council, made up of eminent lawyers, hasn't come about a political decision. I think so.
Nigerians have always seen it that way, but again, how come when they spoke the first time 9 months ago, prone to the government actually did what they wanted it to do? Now they have spoken 72 hours and we're still counting. Nothing has been done when it comes to the reinstatement of Justice Salami.
Well, nothing from the office of the president. Yeah, I think, again, with all due respect, we should be reticent to jump to these conclusions. When ministerial discretion, and in this case a presidential discretion, is conferred by the Constitution, because the NJC can only recommend and advise, the decision will be taken by the office of the president in this case. So he has a discretion as to how he treats the recommendation or the advice. When that is still under consideration, I think it's probably best for the public not to preempt what that decision would be, how the exercise of that discretion would be. I don't think 72 hours, I don't even think a week is too long.
Okay.
But I think the most important thing that we are fulfilling a process. Don't forget, in this country, it's incredible what we go through. We cut new terrain every week, every month. These things are unprecedented. What is going on in the National Judicial Council, what's going on in the legal community, has never happened before in this way. These are provisions of the Constitution that have never been tested, never been used in this particular direction. So it's safe to say that we're all learning the extent of our constitutional powers, and I think there's time enough to wait.
It's interesting because, I mean, if someone were to go through the papers all through last week, what you get to hear and see mostly is that this is still in the realm of, it's not been made official yet, in the sense that they had a meeting, and I think sources, as you usually quote in the papers, told correspondents that it has been recommended that he be reinstated, but it seems nothing formal has gotten to the presidency as of yet. But meanwhile, we're already seeing politicians kicking against it, if again we're going to refer to the papers, saying that he still has a case to answer in court. Now, will all of that, or can that impede his being reinstated, assuming this matter was already before the presidency?
Well, assuming it's gotten there officially, and like you said, the caveat is that you and I don't know for sure. But if the decision of the NJC has been taken, it will be communicated to the office of the president. I think it's a bit preemptory for the political class to start to take, in fact, preemptory decision statements. In fact, these are the kind of, this is what I was referring to earlier on. Even those statements are prejudicial to the exercise of that discretion. When a man has a power before him to exercise, you can prejudice the exercise of that power by making utterances that can influence him either way. Even though it's not a formal court of law, the president's decision is quasi-judicial in this instance. I think it's wrong for people to preempt that decision by making inflammatory comments in the pages of the newspaper. I just think so. So I agree with you.
Is the president bound to do what the NJC has recommended?
No, he's not. And that's it's an excellent question. He's not. It's advice. It's a recommendation. Okay? But in the realm of law, and I'll use it just as an example, which is very similar to this instance, when a body has had primary consideration of both facts and law, comes about a decision. It is only in the slightly extreme situation where that decision has manifestly been brought about by a perverted consideration of the law and the facts, or that it's so manifestly unsupportable in reason and logic that the exerciser of that discretion would overturn it. So it's fair to say that when a body like the National Judicial Council makes a recommendation, unless the exerciser of the discretion can patently see that this is ridiculous, only in such instances would he reverse effectively, because by failing to follow the recommendation, he is reversing the decision of that body that had primary consideration of the facts, received the testimony. Don't forget, the person who's going to exercise the discretion will not hear testimony, will not receive submissions. He will have only the cold record to look at. So in the courts of law, that's how it's normally dealt with. Appellate courts very scarcely would reverse a decision of a lower court on the facts, given the fact that that court had the primary consideration of all the material before it.
I mean, all of this, we really cannot rule out public opinion, public comments out of this, because the way it is, people still will want to bring all of that, even though they know it's just an advisory action that they have given to the presidency, knowing full well that that same body, not a different body, was the same body that gave the same advice, asking that this person be suspended. They felt that by now, come on, that something should have been done. And over the weekend, as Mark rightly said, looking at the papers, some were already saying that, well, all of this is happening because some people are already kicking against it because they feel that there's still some cases in court. Isn't this some kind of indictment on the judiciary? If people are talking about some cases in court, talking about bringing back someone, and everyone is going back and forth on this same matter, politicians to be specific?
Indictment on the judiciary, I don't think so. But yes, it is rather complicated because, as I recall, there is a case that Honorable Justice Salami has regarding his employment generally. There's a couple of other cases regarding the underlying facts about the decisions in question, the gubernatorial decisions. Those cases are still there, but I don't think it disturbs a National Judicial Council consideration of the decision to interdict him. I don't think it prejudices it. And if there is no longer any proceedings before the National Judicial Council regarding his employment, it clears the way for them to say, well, the interdiction can end now and reinstate. It clears the way. I don't want to talk about the propriety of what the National Judicial Council came to, whether it is right, because I don't have all the documents and material that they considered. But it is, in law, it is proper for the NJC to come about a decision now, having gone through the proceedings. Their proceedings, not the proceedings of the court. Don't forget, they're totally different proceedings.
Well, in addition to that, and if I could follow up the question that Salami talked about, they were talking about cases of Salami's call logs in which accused persons are constantly in touch with some politicians, talking about he himself here. And then you also have cases in court which talked about he instituted a case which has not been withdrawn. That's Justice Salami. And people think that, wait a minute, I mean, how could the NJC come to this decision?
When he's still being sued. I find it, yeah. I find that a curious situation as well. I find it curious only to the extent that it's not normal that you'd take your employer to court and expect to still be at work. It's not normal. But again, what is apparently correct and what is legally correct, sometimes there is a divergence. And in this situation, I think this is one such situation where there is a legally correct procedure, which is NJC had full authority to consider it, despite the fact that the case was in court. I don't think it's right for him to still have a case in court while, this is still being considered. But legally, there's absolutely nothing, no impediment legally. And
we also understand that some say it's about the first time, as much as they can remember, that the NJC was actually split on this decision. Usually, this kind of matters, they're supposed to be unanimous. But in this case, they were not.
We shouldn't even know about their voting. But again, it shows you the passion. It shows you the peculiarity of the situation we found ourselves in. And it shows you that we're all in a learning curve. We shouldn't know about the proceedings of the NJC to the point where we can say this is how they voted and this is how they didn't. Unless somebody has breached the normal public service code of ethics, which is not unlikely in this situation because the information is out there. But yeah, I agree with you, Chamberlain. It's an unusual situation.
What would this mean for the judiciary? Do you think that this is maybe coming back to the glory days, or what does this mean for them?
Well, I think it means that the legal community can correct itself. There isn't anything more profoundly precious in a constitutional democracy than a system that can act and internally correct. Whether correct is the phrase, I mean, there will be a disagreement about whether this is correct or that is correct or that was correct, but that there is a process that has been worked through. It shows you that the machinery of justice works. Very much in the same way as if somebody is accused of an offense in the High Court, and 13 years later the Supreme Court says that the system was wrong. All right, it's refreshing to see that the system can work, that the system was wrong, the person was improperly accused, maybe the facts were wrong, maybe somebody lied, whatever. But I think it's very refreshing to see constitutional institutions self-correct without the external intervention of those third parties that we all don't want to see.
There was also the matter of reconciliation between himself and the CGN. Do you think that could actually work?
Well, again, these are matters outside the realm of law. I suppose the CGN, from all accounts, is now in his valedictory period. He's probably...
No, not the CGN, former CGN, Justice Olasupo Shasore.
Well, reconciled because they are colleagues, they are comrades in the legal profession. I think it'll be in the interest of peaceful harmony that they do that, but I'm not sure that it's relevant anymore since they don't occupy the offices. The irreconcilable attitude would have been very important if they still occupied both of those offices, because they would have held on to two major institutions and their personal afflictions for each other would not have borne well for the public.
Was this incident, can we say, sorry Chamberlain, can we say that this incident was good for the judiciary?
No. You can't. You can't say that a situation where two heads of the appellate courts at loggerheads openly accusing each other of serious indiscretions. I don't think it's good for, it's not good for the judicial community, it's not good for the legal community, it's not good for the public. But I think what is good, what is the redeeming factor there is that we have seen a system operate and cleanse, if you like. I don't want you to add any color to that word, but actually correct itself. That's a good development. Without third-party intervention, it would have been sad if there was a clear and apparent intervention from an external force forcing the system to correct itself. That would have been sad. But so what's redeeming about the whole set of situation? The situation is that the system has corrected itself.
How does, or what role does public opinion play in these matters, especially when this kind of matters, even if you have to hand a judgment down? Because we've heard lawyers say that what happens in public opinion stays in the public opinion. It doesn't actually affect what any judgment that is being given by the court.
Yeah.
But you have the public always react in a certain way.
Yeah.
And then you say justice must not just be done. It must be seen to have been done. How do you reconcile that?
Yeah, I mean, the public opinion is very important. And if public opinion had been followed in this bizarre set of facts, perhaps both parties would have been asked to resign or would honorably have offered to resign themselves. And we wouldn't have had to go through the pain of the entire process. I mean, that would have been an enviable way of resolving the matter. And that would have been acting as public officers with the interest and the opinion of the public at heart. And that's the importance that public opinion has. So when you see in the more developed and mature democracies, when you see public office holders resigning office, it's because they are conscious of the fact that they are responsible to the public, ultimately, and not responsible just to the office and the letter of the law that they operate.
How can we learn from this as a nation? Because for some, this is the very first time we get to see someone maybe being asked to step aside, and after a while, he's been recalled. Because before now, when you say step aside for us to investigate your matter involving you, you never get a recall.
That's true. It's not often that happens. But maybe if you went through the law reports, you'd find that it's not unusual for office holders, both in the private world and the public life, to be asked to leave office for the purpose of the investigation. It can easily be prejudicial, and I'm sure that's easy for you to see, that it can be prejudicial for an occupier of an office, a party that is material to an investigation, to be in a position to either alter, influence, or even block the easy process of an investigation. So it's not unusual, but it's not also often that that person gets to be reinstated, because generally the interdiction is based on some prima facie information that tends to act itself out at the end. But it's also not unusual for people to be acquitted of murder after 13 years.